Restaurant bar liability for intoxicated patrons who harm third parties at common law through today. Alcohol has been consumed and enjoyed by humans for thousands of years. Legal ramifications centered around intoxicated patrons visiting taverns, restaurants, and bars have been an ongoing issue dating back to ancient common law. However, ancient common law did not hold establishments liable for an intoxicated patron that caused injury to third parties, themselves, or property. It was believed that the service of alcohol was not to blame for the patron's actions, but rather the consumption itself, therefore rendering the patron responsible for their own actions. During the temperance movement, there was a need to try to contain alcohol consumption by holding establishments responsible for harm caused by their patrons. Actual common law did not evolve. Rather, states created their own statutes to address alcohol liability. The thinking was, if establishments that served alcohol were held liable for their part in over-serving intoxicated patrons, they would take ownership in not serving excessive amounts of alcohol. Liquor licensees would then self-police themselves, thereby helping to prevent foreseeable harm to the patron, a third party, or property. These modern governances on alcohol liability were named dram shop laws. The term dram shop derives its name from the ancient British measurement of alcohol, also known as a dram. Establishments such as bars, pubs, and taverns were known as dram shops. Oxford Languages defines a dram as a unit of weight formerly used by apothecaries, equivalent to 60 grains or 1/8 of a fluid ounce. Dram shop laws are state-issued statutes that open hospitality establishments to civil lawsuits when they overserve alcohol to intoxicated patrons. These laws tend to be similar in many ways, however they vary from state to state. In a few states, dram shop laws actually allow the patron to sue the establishment for serving them alcohol when visibly intoxicated, if the patron sustained injury due to their level of intoxication. In order for liability to be placed upon the licensee, specific elements need to be met. The elements of a claim are the establishment or licensee must be licensed by the state to sell alcohol. The patron must have been visibly intoxicated and continued to be served alcohol, and the intoxicated patron must have caused damage or injury to the plaintiff or plaintiff's property. In addition, the specific serving of alcohol by the establishment or licensee must have been the direct cause of injury to a third party. In 1849, Wisconsin passed one of the first known dram shop laws within the United States. By the 1870s, many other states introduced their own dram shop laws. Let us look deeper into an example of a state dram shop law. Pennsylvania passed their first dram shop law in 1933. Having evolved from an older statute which continued on to be further codified in the 1951 Liquor Code, making licensees responsible for serving visibly intoxicated patrons who then cause harm. In 1958, the Pennsylvania Supreme Court affirmed that the purpose of the dram shop law was to protect both the public and intoxicated patrons. Pennsylvania dram shop laws do not apply to any person, but instead place responsibility on specific persons or entities. To establish liability, the defendant must be a licensee or acting in part for the licensee. In addition, the absence of profit or commercial sale of liquor renders the Dram Shop Act inapplicable. The Pennsylvania Supreme Court case, Clark v. Dairy Farmers of America, serves as an effective example. As Sarah E. Argo writes in Defense Digest, Volume 29, Number 4, Dairy Farmers of America sponsored a golf outing for its employees. Dairy Farmers of America required its employees to provide a monetary contribution to offset costs of green fees, food, and alcohol associated with the event. During the event, Roger Williams, an employee of Dairy Farmers of America, became intoxicated and was involved in a motor vehicle accident with David Clark. Clark sought to impose liability under theories of common law negligence and violation of Pennsylvania's Dram Shop Act. The Pennsylvania Supreme Court refused to extend the scope of the Dram Shop Act to include an organization such as Dairy Farmers of America that hosts an event at which alcohol is provided but is not a liquor licensee. Clark argued that Dairy Farmers of America fell into the any other person category of the Dram Shop Act, and by collecting money from its employees to purchase alcohol for the event, dairy farmers received consideration and then sold alcohol to a visibly intoxicated person. The Supreme Court declined to extend the scope of the Dram Shop Act and explained that the act listing any other person is not applicable in this case and does not mean that every individual within the Commonwealth is exposed to dram shop liability. The Supreme Court went on to say that the meaning of any other person simply refers to persons whose actions place them into the same category as the preceding entities, such as those who engage in the commercial sale of alcohol for profit. Clark also raised a common law negligence theory of liability. However, Pennsylvania courts uphold the long-standing precedent that there is no social host liability at common law, and competent adults are responsible for their own actions. Pennsylvania does enforce a social host liability law limited to serving alcohol to minors. If you are hosting a party and serve alcohol to a guest under age 21, and they cause any sort of damage, you are likely to be held liable for damages and possibly face jail time, even if the minor was not visibly intoxicated. Alcohol is socially and responsibly consumed by millions of people around the world. Overall, within most states, there have been significant statutes and amendments that have been passed with the intent of protecting its citizens when it comes to alcohol consumption. We may never know to the full extent the number of lives that have been saved due to the drafting of these type of statutes.